In the motorcycle accident case, not only did we have to prove liability, but we had to prove damages. Kind of an interesting point of the liability part was that South Carolina at the time was a contributory negligence state. That means if my client contributed anything, even 1% to the accident, he could collect nothing. As I discussed in my previous video, we were convinced the judge he did nothing wrong. But then there was still the issue of damages. He was injured badly, he was burnt, he had lost the use of his right arm and lost a part of his left leg, which left him with a severe limp. And he was an electrician in a power plant, and his head injury kept him confused, such that if you're running around in high power plants, you can't be confused, you get killed. The government claimed, well, he's not all that confused and his arm can still be used. And oh, by the way, he doesn't even have a limp, which seemed surprising to me since you could see him have a limp. In any case, the government's position was not only was there no liability, but the damages, of course, were not so great. One of the big parts of contention was the ability of my client to be mobile. They had sent my client to an independent medical doctor to review his condition. This doctor came back with the conclusion that he had a normal gait, that he could walk normally and move normally back and forth, which seems to me that it was almost impossible since my client had lost a quarter of an inch of his bone on that road that night and limped. Anyway, that was the position of their doctor, and at trial that was their position as well. And their doctor's on the stand, and he was testifying about how they had interviewed my client and done their exam, and my client turns to me and whispers, "I've never seen that man before in my life." I've heard that before, but I asked him, I says, "You 1,000% sure? Because I'm going to go after it if you are." And he goes, "Dave, I'm sure." So while he's on the stand in front of this federal judge, I ask him this question. "My client just told me he's never met you in his life. Have you, in fact, met my client?" And the doctor stammered and stomped and kind of hemmed and hawed around, and he says, "Well, not really." I said, "What do you mean, not really?" He goes, "Well, some other doctor actually reviewed this, and all I did was look at some notes." I says, "So you never saw my client walk or not walk, and whether he had the limp or not limp at all. Isn't that correct?" And he said that that was true. And I says, "Is there anything else true about your testimony in connection with your arm, his arm, or his cognitive ability to think?" And he had to admit that he, in fact, although he stated he did review my client, had to say he really didn't. The judge turned to him and said, "Get out of my courtroom. I never want to see you again. If he ever comes back here again," and he turned to the Attorney General and said, "I'm going to hold you in contempt." Well, needless to say, after that little interchange, the judge believed all the damages that we had to present and none of the defenses that they claimed my client couldn't work or could work or somehow wasn't limping or that his arm was exaggerated. It only goes to show you that hard work, in-depth study, and sometimes just the truth between the plaintiff and his attorney, when he had the courage to tell me, "You know, Dave, I've never seen that guy before in my life." And turns out he was right. We proved it, and the government's defense on damages, quite frankly, collapsed. And I believe that was one of the major reasons why we ended up getting $2.75 million. And we got $800,000 for the passenger on the vehicle that day, too. The court decided it was going to believe everything the plaintiff put up for damages, and they accepted what we put up to the dollar.